To the story now, Eskom blames wildcat strikes for the intensification of rolling blackouts. It also says it's suffering a high level of absenteeism due to intimidation of workers. Eskom is considering an essential service and its staff are not allowed to strike. Let's discuss how essential staff should air their grievances with Hugo Pienaar from Cliff Decker Hofmeyer. Mr. Pienaar, good morning and thank you very much for your time. You know, there's been a lot of finger pointing now with Eskom basically placing the blame on workers and even going as far as emphasizing the fact that they are essential staff workers. So meaning that this would have been an unlawful strike, which has necessitated some sort of a conversation around the rules of engagement insofar as essential services are concerned. Just take us through the provisions of the Labour Relations Act, particularly when we look at disputes by those engaged in essential services.
Thank you, Mfundo. Well, what people often forget is that Eskom is not only an essential service, but it's also a national key point in terms of that key point legislation. So it has a sort of double protection almost. The one is that employees in that industry, in an essential service industry, would ordinarily not be entitled to strike, and the court has just declared the strike to be unprotected. And their rights in terms of that is then substituted with the right to have wage disputes adjudicated by an arbitrator. So ordinarily you have Section 23 of the Constitution that entrenches the right to strike, but Section 36 of the Constitution limits the right to strike, and it says that when you deal with an essential service, those employees may not strike, and their disputes are adjudicated by an arbitrator, their wage dispute.
So what blame do we apportion to unions here? Because they've always been familiar with the rules of engagement and that it would need to go for arbitration in this instance, but opted to go this route, even though we've heard them say that they need to normalize the situation, that's the workers. But nevertheless, how much blame can we apportion to them in this respect, given what has happened to ordinary citizens, how we're suffering with blackouts?
And you're absolutely right, and that is the sad reality, and that's why people often forget that there's also criminal accountability provided for in the terms of the Criminal Procedures Act for anybody that would infringe or damages or tampers with an infrastructure such as that of Eskom. And the question is whether the current conduct would fall within that category or not. So the answer is simple to that: they can't strike, the unions know that, but unfortunately, and Van Niekerk alluded to that already in his 2012 judgment in Tsogo's Sun, where he said, unfortunately, our labour landscape during wage negotiations is tampered with in the sense that the unions almost act with impunity. There's mob justice. He referred to it as a tyranny of mob justice, and that's sadly the landscape that employers, not just Eskom, operate in our South African labour landscape. And that brings you then to the issue of where's the police in all of that, because they're duty bound to protect. And you get a court order and you simply don't get the police. Where's the military in all of this? And what about ultimate accountability if there is an infringement of those laws?
But among laymen, there seems to be another debate that's bubbling under here. It seems that they're of the view that greater emphasis is placed on the responsibilities or obligations of the employer. Employee rather, insofar as them being essential workers, but very little emphasis on the obligations or responsibility of the employer to ensure that the working conditions are adequate, that they have their benefits as essential service providers, because there were some that spoke anonymously to newspapers and they stated that we are told daily that we are essential service providers, but really our benefits and our remuneration does not reflect that we are in fact essential service providers. So how much responsibility then do we also apportion to the employer to say, if you're going to go into negotiations with essential service workers, responsibility is yours to make sure that you don't deadlock, or you come humbly, not as arrogant as they claim the employer had come and said, we're not having this conversation around salaries. So how much blame do we apportion to them in this whole situation that we're in as ordinary citizens who had nothing to do with what happened there?
It unfortunately becomes a blame game. And you often have the parties blaming one another. But the point is they operate within the auspices of the law. there are certain limitations and duties on both parties. The employer is duty bound to ensure that it complies with its obligations in terms of legislation, labour law and otherwise, and if it doesn't, then there are mechanisms for them to be held accountable, whether it be before the labour court or otherwise, and the same with regard to the trade unions on the other hand and the employees. In wage negotiations, of course, it's typically a dispute of interest. So people take a position. Employers would say, look, I can't really afford more wages. Or in Eskom's case, I've seen an article yesterday where they say the employees, they are paid on average about the third highest in that type of category in the country on average. But in a normal environment, that's a dispute of interest where people would go on strike and the employer can lock out, and there are mechanisms in terms of the Act. In this case, there are different mechanisms put in place, i.e. arbitration. And that means that if the employer goes into this process on an arrogant basis, the employer will suffer the consequences of that during arbitration proceedings. So there are mechanisms in terms of the Act to address the behaviour of both parties, and they must act responsibly, as one would expect them to do.
You know, I know this is a bit technical, but I think perhaps it is to the benefit of others that are still confused as to essential service workers not absolutely being allowed to strike at any point. If we had to venture into the provisions of the minimum services, it seems to me, I was just browsing through the Labour Relations Act, and I found that they do have that little bit of leeway to say, if there was an agreement signed between the employer and employee to say, we will provide a minimum service to you, then we could still continue to protest. Does that perhaps assist in such respects where you do embark on some sort of protest action, but you first sign an agreement to say, I will give you the bare minimum at the very least to ensure that you don't have or suffer the consequences as we're suffering now? Would that have been beneficial in this respect where they entered into such an agreement before?
Well, there are provisions for minimum services as there are provisions for maintenance type of services. But of course, the bottom line is, as you've indicated, you need an agreement. And ultimately, Eskom is duty bound to render its services, and hence it's an essential service. And if there's no agreement to address that, then the bottom line remains that those employees can't strike. And that's the law. And we must either abide by the law or not. And as I've indicated, there's ample provision in legislation to address behaviour and non-compliance of both parties. And one would ideally want, for that type of agreement, if you want that and if it's possible, to come into play via the introduction of a proper mediation process. That often assists parties in getting there. But again, the point you're making, you don't want that sort of issue to come to the fore when people are about to enter into wage negotiations. You want that in the preceding 3 or 2 years, depending on how long the agreement operates.
Correct. Mr. Pienaar, thank you very much for your insights. That's Hugo Pienaar from Cliff Decker Hofmeyr.